in a packed Florida courtroom. Tensions were high during a routine property dispute case. The room buzzed with anticipation, not because of the case itself, but because of an unusual sight at the defense table. A teenager, no older than 17, dressed in an oversized suit and adjusting his glasses nervously, was preparing to address the court. His name? Alex Monroe. His role? According to court records, legal counsel for the defendant, Judge Harold Whitmore, a stern man with over 30 years on the bench, furrowed his brow as he glanced over his glasses. "Is this some kind of prank?" he asked, his voice echoing off the marble walls. The courtroom snickered. Even the bailiff cracked a smile. Opposing counsel, a seasoned attorney named Deborah Langston, chuckled under her breath. "No prank, Your Honor," Alex said calmly, standing straight. "I've been authorized to represent Mr. Raymond Jeffers under Florida's pro-esse assistance statutes." The judge leaned forward. "You're telling me you're representing this man in a court of law?" "Yes, sir," Alex replied. "With the court's permission." Whitmore scoffed. "Permission? Son, this isn't a high school debate. Do you even understand how civil procedure works?" The laughter returned. The judge wasn't hiding his disdain now. "Let's not waste this court's time. Where are your credentials? Your legal guardian here? Does your mom know you're playing dress-up?" Alex didn't flinch. "If Your Honor would allow me to proceed, I believe I can demonstrate that I'm fully prepared to argue this case." "Fine," Whitmore said with a mocking wave. "Impress me." What happened next will leave the courtroom in stunned silence and rewrite court protocol history across the state. The case itself was a relatively minor civil matter. Raymond Jeffers, a 54-year-old mechanic, was being sued by a developer for squatting on what was claimed to be company land. Jeffers had been maintaining and living on the property for over 20 years, believing he had a verbal agreement with the previous landowner. With no formal title in his name, the case was a near-guaranteed loss. That is, until Alex stepped in. "Your Honor," Alex began, "the opposing counsel claims my client has no legal right to remain on the property. But under Florida's adverse possession statutes, specifically Chapter 95.18 of the Florida statutes, my client's continuous, open, and hostile occupancy over a 20-year period entitles him to file for ownership." Judge Whitmore raised an eyebrow. "I'd like to submit Exhibit A," Alex continued, handing over a thick file, which includes utility bills, tax payments, and testimony from neighbors verifying uninterrupted occupancy since 2003. Langston, the plaintiff's lawyer, was visibly annoyed. "Your Honor, this is absurd. A child citing adverse possession." "He's not wrong," Whitmore muttered, flipping through the file. "These documents are thorough." Alex didn't stop there. He cross-examined witnesses like a seasoned litigator, calm, confident, and surgical in his questioning. He caught inconsistencies in the developer's records, proving that no taxes have been paid by the company for that parcel of land in over 18 years. He even uncovered a zoning map that showed the disputed land had once been excluded from the developer's plans entirely. Each move tightened the noose. By lunchtime, the mood had changed. There was no more laughter, no more whispers. Even Judge Whitmore had stopped making sarcastic comments. He now watched Alex with a mixture of curiosity and disbelief. During recess, reporters flooded the hallway, asking, who was Alex Monroe? That's when the truth began to surface, and it stunned everyone. Alex Monroe wasn't your average teenager. In fact, he wasn't average at all. At age 6, he was reading Black's Law Dictionary for fun. By 10, he had completed online law courses in constitutional law, contract law, and criminal procedure. He graduated high school at 13 and passed the LSAT at 14 with a score of 177. But due to age restrictions, he wasn't permitted to officially enroll in law school. Undeterred, he audited classes at a local university and volunteered at the county courthouse, where he met Raymond Jeffers. When he learned about Jeffers' situation, Alex knew he had to help. With Jeffers' consent and a little legal creativity, Alex filed a motion as a pro-esse assistant, an unconventional but not entirely prohibited role in Florida civil proceedings. The court, either by oversight or curiosity, allowed it to proceed. By the end of the second day, Judge Whitmore called both parties to deliver his ruling. In all my years on the bench, he began slowly, I have never encountered something like this. He looked directly at Alex. When you walked into this courtroom, I saw a boy pretending to be a lawyer, but I was wrong. You're not pretending. You are a lawyer in everything but the license. A quiet gasp moved through the room. Whitmore continued. Mr. Jeffers has proven, through compelling evidence and sound legal argument, that he qualifies for adverse possession. I am ruling in his favor. The motion to evict is denied. Alex closed his notebook. No smile, no fist pump, just a deep breath of satisfaction. As the courtroom erupted in chatter, Whitmore leaned in again. Young man, I mocked you. I regret that. You have a gift. And I suggest you find a way to use it within the system, because it could use more minds like yours. Alex Monroe's story didn't end there. The case went viral. Legal scholars across the country debated the ethics and legality of his courtroom role. Some critics argued it undermined bar standards. Others hailed it as a testament to raw talent and initiative. Within weeks, 3 law schools offered him honorary admission. A state senator even proposed a bill that would allow exceptionally gifted minors to sit for the bar exam under special review. As for Alex, he turned it all down for now. I'm not in a rush, he told a local reporter. I don't want to just be a lawyer. I want to change how the law works for people who need it most. And true to form, he's now quietly working on an app to help people understand their rights in housing disputes, starting with the very statute that won his first case. Moral of the story? Don't judge a book by its cover. And don't underestimate the kid in the oversized suit. He just might be the sharpest legal mind in the room.